Good morning. Today we are going to see the defense which are available in negligence. In the previous two videos, we have seen the essentials of negligence and the nature of negligence. Now we are going to discuss defense. There are three defense available in negligence for the defendant. The first two are the vis major and the second is contributory negligence. These two defense we have previously seen in the video named defense in tort. These two defense are available in general tort also, and this defense is available for negligence also. Better you see that video to understand these two defense. Today we will just discuss the important defense which is available in negligence for the defendant, and that is contributory negligence. Contributory negligence means what? The plaintiff is the wrongdoer. Here the injury is caused partly because of the wrong done by the plaintiff and partly by the defendant. The reason by reason of his own wrong, the plaintiff has suffered some loss. Every person is expected to take some reasonable care, and plaintiff has not taken that care. Therefore, he himself is responsible. Therefore, what the defendant is going to tell? See, here the plaintiff is responsible for the injury caused. When a person is putting his hand out of the window when the railway or when the bus is in motion, and if he gets injured, then he himself is liable. He cannot make the railway company or the bus company liable because he is the best judge for himself. Why he has taken out his hand when the bus is in motion, isn't it? Therefore, plaintiff is liable. Negligence of plaintiff is called as contributory negligence. Contributory negligence is a good defense because here the defendant is going to tell, see, the plaintiff is contributor. Now, this contributory negligence as a defense is not available in 5 different circumstances. Means here, though the plaintiff is a contributor, he is partly responsible for the wrong, but he will get compensation because this defense is not allowed to the defendant. The first is, we are going to see here the exceptions for contributory negligence. Means this, in these 5 circumstances, the plaintiff is going to win the case, though he is a contributor. So the defendant will not be allowed the defense. 5 different circumstances are there. The first is where rightful acts are assumed. When rightful acts are assumed by the plaintiff, he feels that the defendant has done his duty and therefore he does something, and the defendant has not performed it, therefore he suffers a loss. Plaintiff is a contributor here, but he will get the compensation. We'll see one case. When you see different cases, you understand the point. Therefore, tort law is considered to be a case law. Full of case laws are there. So in this, to understand the rightful acts are assumed, we will see one case. The name of the case is Gee versus Metropolitan Railway Company. The plaintiff is in the railways with his brother, and the railway is in motion, and he stands up and he feels the door is been closed. Therefore, he is showing some object to his brother, and therefore he puts his hand to the bar. He feels that the door is locked, but as he puts the hand to the bar, the door is not closed, the door is opened, and he is being thrown out of the door and he gets injured. The railway company is telling that why you stood up, why you put your hand on the bar. But here his contention is that I had assumed that the door was closed, and if the door was closed, then it would not have opened though I had put my hand on the bar. So he had assumed certain things that the plaintiff has performed, and actually the defendant did not perform it. Therefore, the plaintiff will get compensation here. Where the plaintiff has assumed some rightful acts done by the defendant, Though the plaintiff is a contributor, he will get the compensation. This is the first circumstances. The second is where the defendant had the later opportunity. Okay, the plaintiff has done some wrong here. We assume that plaintiff has done some wrong here. But the problem could have been solved if the defendant was active. Because if the accident happened not only because of the plaintiff but because of the defendant, and the defendant had an opportunity to control it, he had the latter opportunity. We'll see one case, that is Davis versus Mann. In this case, what the plaintiff did, he tied his donkey, he tied the legs of the donkey, and he has put the donkey on the road. So what happens? The donkey is on the road, he is trying to stand up and all. At that time, the defendant, he comes in his car and he is in a very high speed. When he comes near the donkey, at that time he sees the donkey. At that moment, he is not able to control the speed and he injures the donkey dies and all. Therefore, the owner of the donkey, the plaintiff, has filed a case against the defendant that because of the accident caused, my donkey has died. You have to pay me the compensation. Here, the defendant is telling why you have put your donkey on the road. You are responsible for that. But the court has held you had the later opportunity to control the accident. As you were in a very high speed, you could not control, and therefore the accident has occurred. Therefore, contributory negligence as a defense will not be allowed here. This is a second exception. The third exception is doctrine of alternative danger. Means if this would not have happened, the other thing would have happened. Either or, and something would have happened. Either or injuries would have taken place. That is called as alternative danger. The case is Ridley versus Mobile Railway Company. A engine of the concerned railway company was there. It was coming in again in a high speed and all, without any horn, without any whistle. A small boy who was sitting on the track, means he was sitting on the track, he was a wrongdoer, but his back was there. He couldn't see the engine was coming and the back side without a whistle. So without a whistle, engine is coming, it itself is some negligent act. So what that plaintiff sees, that a boy is sitting, the engine is coming without a whistle, that boy will not come to know, therefore it is going to cause harm to him. Therefore he rushes fast to save the boy, to rescue the boy, and he brings him outside the track. But at the same time, he falls and injuries are caused to him. Here the railway company is telling why you came to rescue the boy. But law is telling if he wouldn't have come to rescue the boy, what would have happened? The boy would have died. Means either or, railway company would have been responsible. It is better that the boy is living and he just injured. Therefore, pay compensation to the plaintiff. So, if alternative danger doctrine applies, there also the contributory negligence as a defense will not be allowed. The fourth exception is children. When children are there as the plaintiffs, though the children are wrongdoers, maybe they have done some wrong, but they are eligible for getting compensation because they are children, they don't understand. You have to understand it. You have to take care of the children. The case here is Glasgow Corporation versus Taylor. Glasgow Corporation's garden was there, and in that garden fruits were there of a poisonous tree. The fruits were poisonous. They were of red color. Imagine, red color fruits are there, alluring to the children. Therefore, the children who were playing in the garden, they come there, they take some fruits and they eat it. Many are injured, one boy dies. Therefore, the case is being filed. The corporation is telling the children have eaten those fruits by themselves. We didn't tell them to eat. They have taken it. But the court has held having a poisonous tree in the corporation garden itself is a wrong thing. Therefore, though the children have taken the fruits themselves, they are eligible for getting compensation. Therefore, contributory negligence as a defense will not be allowed for children. And the last is maritime law. Relating to sea matters, contributory negligence as a defense is not allowed. When there is a collision in the high seas of two ships, and when there are no provisions, no proof to check whether which ship was responsible, at that time we consider that both were responsible 50-50%. So we don't see there because there is no facts or there is no evidence available to see. These are the 5 different circumstances where contributory negligence as a defense will not be allowed. Now recently what changes have taken place? We calculate the contribution. We see whether plaintiff is negligent, then how much percent. Defendant is negligent, then he is responsible for how much percentage. That percentage we check, and as per the percentage we reduce it. We reduce the compensation. If the plaintiff is negligent, he is a contributor for 40%, then the compensation will be reduced by 40%. Means we will check here who is contributor for how much, and accordingly now compensation is being given. This is a recent trend which we have brought in law. So these are the defenses in the tort of negligence. Okay, bye bye. See you in the next video.